Rick Davis. Well, he joined Mary many years ago. I didn't look back to see how many years ago it was. He came to us as a real estate attorney. He did investing on the side, so he studies real estate and he knows the real estate law. Then he started a title company a few years ago, and he closes a lot of deals with wholesalers, real estate investors, and he knows all the crazy ideas that we come up with that we want him to make work. So he's also knowledgeable there. He's also quite busy with advocacy. You might find him in Jefferson City or in Topeka, finding out what the legislators are doing and what they might be thinking about. So he is uniquely qualified to talk about our subject today, which is kind of what wholesalers do in general and what's right, what's wrong. And then along with his wife and 3 kids, you might find him at a KU event or at a sporting event. So Rick, welcome to our show.
Perfect, everybody. I'm looking at who is here, and I think that, at least half of you I know pretty well. And I see a couple names that maybe I don't know. So, welcome to everybody. Hopefully you'll find this hour to be enjoyable. Those of you that don't know me, I am pretty informal. So do definitely pop up any questions that you have as we go along. I'm going to see if I can get the chat back up because when I did the PowerPoint, it knocked it down. Usually I'm pretty good at reading those, but again, throw those up. I know Kim will interrupt too and let me know if there's anything. And hopefully I'm going to try to pack a lot of stuff into an hour. So some of these topics probably could be an hour on their own, and maybe we will do other stuff too, on a different date on some of these topics. But I want to kind of cover, just some different ideas and different concepts that get back to this core question that, as Kim put for the title of the event here, why you can't represent a buyer or seller as a wholesaler. And I know that there's at least somebody on this or who will watch this later who's going to cringe at me saying that. I know there's at least a person or two on here that's closed files at my title company and has been frustrated at times when maybe I've said, hey, you can't represent a party, or this is why. And so hopefully this chat over the next hour is going to help you kind of understand where that comes from and really kind of base it in the laws and the rules, and talk about kind of what the laws are that apply. And also just talk about some of that kind of regulatory stuff. Why are there more pushes towards regulating wholesalers? Where are those coming from? Where do I think and where do I see where those are coming from? So anyway, with that, we'll kind of jump into the topic here. So Kim already did a good job, but I'll go ahead and hit it a little bit more too, without trying to recap. Like I said, I currently own RD Title and Exchange. We're a title company, and I am going to kind of say, and I'm not going to touch on it too much in this topic because that's not the point of the talk. The moment we're not accepting any new files right now, kind of phasing on to other things. And I'm going to talk about why I think that's relevant in this conversation in just a moment too, because one of the themes we're going to talk about today is the concept of conflicts of interest. And so I just kind of keep that idea in mind. But again, we are a title company. We've worked primarily, almost exclusively with real estate investors. I think at last count, just short of 5,000 files we've closed. Probably 90% of them were wholesale deals in one sense. And so definitely something I've seen a lot of before that, and still am an attorney, although I don't practice law. I worked actually too, and I don't go this far back in my history a lot. And so I think even the people that know me may not know all of this. I previously worked kind of as outside in-house counsel for 2 different large mortgage and servicing companies, Aquin and ShellPoint. And so really everything related to real estate, mortgages, things, that's what's in my blood. It's what I've been doing for a long time. Beyond that, I am also a licensed real estate broker. I do my own investing. I have a home investors franchise based out of the Topeka, Manhattan area. So the We Buy Ugly Houses people. So kind of all around different ways that I'm kind of tied into the real estate investor community and world and see these things. So like I said, we're going to talk about conflicts of interest. We're going to talk about big question here. Why should you listen to me? So why is anything that I'm going to say over the next hour something that you should care about or consider? And I'm going to tell you the biggest reason is because I'm not selling you anything whatsoever at all. And so, like I mentioned, we're not taking any new files to the title company right now. I don't practice law, and I'm not selling any gurus or consulting courses or training courses. Literally, I am here because I like this community. I like real estate investors, and I love Kim and her group. And so that's what I hope you know as we talk. For the next hour, we're going to talk about conflicts of interest. Just for a second, lead in with that concept of, again, why you should listen to me. I'm not selling you anything here today. So, all right. So, as Kim mentioned, kind of talking about different key terms, I'm going to gear parts of this conversation so that someone could be watching it who's never done anything in real estate investing. There's going to be parts of the conversation that I think will be geared to those that have done thousands and thousands before. And so I want to start with this concept of what is wholesaling. And so when we talk about wholesaling, I think that the term gets conflated at times, or gets confused and gets used for really things that are two different things. And so I mentioned a minute ago, I have a home investors franchise. In their training, they actually don't talk about wholesaling the way that most people around here in Kansas City do. They break it up into the concept of assigning and wholesaling. And I've always felt like that's a good way to do it and that that's a good differentiation. And so I want to lead in with that and talk about that. And as I talk about things, I'm really going to try to break that up and talk about assigning versus wholesaling and what's the difference. So, wholesaling at its core, the actual term wholesaling is the same as what you see happening at a Walmart or a Target or wherever, your Dillons, your grocery store, where you're going to see a lot of things are wholesaled. So, in other words, they go through a wholesale company that buys that product. They then sell it to the retail person. So, really, how wholesaling in real estate started in the original idea is exactly that. That's a real estate investor that's going to purchase a property and then they're going to resell that property. The timing of whether that's the same day in a double close or it's 6 months later, it doesn't really matter, but that's the idea of wholesaling. It's not flipping, it's not doing work into the property, it's just buying it, reselling it for a profit. Assigning is similar, but and is what we see 90% of the time in the Kansas City market, or at least I'd say with 90% of individuals, maybe not volume. But what we see a lot is assigning, which is a little bit different. And so in that instance, that's someone who is getting a property under contract and then selling the rights to the contract. And so for some of the stuff we're going to talk about today, the difference there isn't one. The same kind of concepts apply. But for some of the things that we talk about, there are going to be differences. And so I wanted to kind of mention that and kind of mention, too, kind of where that comes into play. So, all right. So as I talked about, I want to kind of talk a little bit about what's happening with wholesaling and kind of why we have the negative perspective or why people begin to get negative perspectives of wholesalers. And I'm going to start with saying this. Again, I tried to do a count the other day, and I think it was somewhere like 300 and some different wholesalers that I've worked with in the title company capacity. And like any business, you could talk about the NFL, right? You've got the stand-up man of the year guys, and you've got the ones that are abusers and end up in jail. There's a lot of that same concept in real estate investing, and particularly with wholesaling. And so you're going to have the people that are honest, that do everything right, and are probably most, if not everybody that's on this right now, because the fact that you care to be here shows you care about doing things right, right? And then you're going to have the people that don't. And unfortunately, a lot of the regulations and things come in for the people that don't. But I think what I want to talk about a little bit today is that some of it though is not just that side. It is the rules kind of come from the people that do things wrong, but we also have the people that are trying to do everything right and doing the best they can, but maybe overstep that line because they don't know or don't realize it. And that's the things I want to kind of get people thinking about today. And so again, kind of why is wholesaling or assigning, in this instance, I think you can use both, controversial, or why do people get upset with it? There are kind of a few main things I think that most people look at. So, and one of them, the first one is what we're going to talk most about today, and that's this idea of misrepresentation. And so it's not, and I'm not using that sense even in the sense of someone is lying to someone or misrepresenting something about the house, but a lot of times it's just not understanding rules. And so I see it a lot as a title company that a seller actually refers to the wholesaler as their real estate agent, even if that person's not licensed, or they think that that person is their real estate agent. And that's really part of where it starts to create problems at times, is because these sellers often think that this person is looking out for their best interest. And that doesn't mean that you're not. Again, I've worked with tons of great wholesalers that are trying to do everything they can to help a seller. But again, I think over the course of the next hour, we're going to talk about a little bit where those kind of conflicts come into play. Other concerns, just lack of transparency. So the seller doesn't understand that you're buying for less than market value. Obviously, there might be reasons why they are, whether it be probate, whether it's a need to sell quickly, whatever it might be. And, a lot of times they know this, but other times they don't. And that's where you see the regulators coming in and getting concerns. And then lastly, and we're not going to talk about this at all today, but what I'd call not real buyers concept, which is the people that go out there, and I know we've all seen it in Kansas City, and a lot of them are based from other places in the country. Not to say there aren't ones here too, but that just go out there and throw high offers. They, call the person, they probably never see the house in the first place. They throw out a high offer, get it under contract, and then their plan is we're going to shop it around, see what they get, and they'll come renegotiate. I think that's also, or they just walk away, which is even worse. So you've got a seller now that maybe has been working on moving. I dealt with this exact scenario. I can think of, about a year ago, this was a person that lived in kind of Southwest Kansas, and we would do stuff throughout the state at different times. And this was a seller that had been working on moving to Oklahoma. And I think she said she had done 6 trips in her pickup and had paid for a storage unit. And this was a wholesale deal, and the wholesaler just didn't close. And so those are the things that really kind of get, wholesaling a bad name. Again, we're going to focus on that first one more today. The last thing, though, and this is the big one too, which really ties into that last point, and really this could be an entire hour topic itself, and I'm not going to talk about it any more than just 30 seconds now, but is especially tied in with that last set of wholesaler, the people that go out and just throw the big offer out there, then they throw an affidavit of equitable interest on file, trying to prevent it from closing later, potentially preventing it, and asking for a payoff for a few $1,000s to go ahead. And so those are kind of the ideas, I think, of thinking about why we're having more regulation that's coming into wholesalers. It's really coming from those concerns. And again, today I want to focus on that bullet point 1, because I think bullet points 2 and 3 are more the bad actors, whereas bullet points 1 are the good people. It's the good wholesalers, the good investors that are maybe trying to help a little too much, and sometimes kind of overstepping that line. Real quickly, we'll talk about different wholesaling regulations that have come into place. As of this point, there isn't a whole lot of regulation in Kansas or Missouri. Kansas did this last year, pass a new law allowing them to get a little more enforcement ability on the existing real estate rules, but they haven't put in any kind of new wholesaling specific regulations. But it doesn't mean that that's not going to happen. There have been bills introduced every single year in Kansas for the past 5 years. A lot of states near us, if you're in Missouri, Illinois touches over there. We got Oklahoma down below us. Those are both states that have put into place different rules. Most commonly, the rule is to require the person to have a real estate license, but that doesn't really fix everything either, which we're going to talk about in just a minute. Also, rules related to how they can advertise, how they have to disclose, that kind of thing. It's like I mentioned here are the requirements. So Illinois, you have to have a real estate license. Oklahoma requires certain disclosure and often licensing, that kind of thing. All right, so this is where we're going to get a little bit into the weeds. And so if I get too far, please go ahead and anyone pop any questions up here. But I want to talk specifically, about kind of the laws related to real estate. And so as we're thinking about this question of can a wholesaler represent a party, I think the first question that you need to ask yourself is, well, is the activity that the person is doing something that requires a license? And so there's going to be a little bit different discussion as we go through between wholesalers that have a license and wholesalers that don't have a license. And so I think to start with, let's talk from that perspective of a wholesaler that doesn't have a real estate license and whether or not those are required. And so this literally is copied straight from the statute. I meant to put the reference there, but it looks like we missed it on that one. But this is literally copy and paste from the statute in the state of Kansas. We'll talk about Missouri in a second. It's very, very similar. There's a little bit of difference, but these are kind of the things. And so I'm not going to, like most good attorneys, I'm not going to necessarily give you all conclusions on a lot of things. There are some conclusions on my last couple slides, but a lot of it I want us to just think about some of these questions. And so again, if you look at the activities that require a real estate license, we've got selling, exchanges, purchase, leases, real estate, or offers to sell, exchange, purchase, or lease real estate is the first 2 points. And I think as you look at those 2 bullet points, that's going to raise the issue that I think is the most common that you see discussed when we're talking about wholesalers and whether or not they need to be licensed, which is the concept of, are you selling a property or are you selling a contract? And so I think there's been a lot of attention to that issue that's gone on over time. I'm not going to necessarily go into that in a lot of depth here, because I think you can probably find 15 threads with a quick search on Mari talking about that. But it is an important thing to keep in mind. I mean, clearly, if you are advertising the sale of real estate, so if you were saying, I've got 1, 2, 3, 4 Main Street for sale, and you are not licensed, that is something that's clearly going to fall within the statute. There's really no question there. Where things I think get a little bit more discussion that I don't think gets enough attention at times is some of the other bullet points. And so thinking about, for example, negotiates or offers to negotiate the sale. Depending on how your deal is structured with your seller, you could be coming into those kind of areas there. I think also assist or directs in the procuring of prospects calculated to result in the sale or assist in negotiation. I mean, just think about those different concepts. And again, kind of where they fall in as to when you would need to be licensed. Again, we'll pull up Missouri here. Missouri has kind of similar rules, a similar statute. You can see for the most part, these are the same. I think the other one that kind of is relevant too is when you talk about dealing with options, because whether these assignment contracts or options could be a question at times too, depending on how you've worded your thing and how many outs you've given yourself and that kind of thing. So, all right, so we're going to hit that for a second. I'm going to hit one more law thing as far as regulations, because I don't think we've talked about this set of laws much at all in the Kansas City area. And they come into play again. A large number of the files I've seen over the years involve sellers that are in foreclosure. And I think a lot of times the services that are being provided by wholesalers might fall within this category. And I do know of at least one litigation case with an investor right now who is being accused of kind of violating some of these laws. And so, in addition to thinking about the real estate licensing law, another thing is to think about these foreclosure consultant laws. And so this is kind of a generic definition that's used in a lot of states that have these laws. And it's a foreclosure consultant is an individual that offers services to a homeowner to prevent or delay foreclosure, including loan modifications, forbearance agreements, and refinancing. And so I'm going to talk a little bit more about the Missouri law specifically. But I think for those of you that are on this right now that are dealing pre-foreclosures, especially in Missouri, this is something to think about whether or not you would fall under this category of a foreclosure consultant. Are you advertising to people that your service is to help stop, delay, or prevent a foreclosure? So this is the Missouri statute. So what I gave you previously was just kind of a generic that was kind of a generic definition of the foreclosure consultant rules. This is the actual Missouri statute. You can see the reference here, 407-935. And these are the specific services that are applying that they are considering to be foreclosure services that require you to comply with this foreclosure consultant law. The first is stop or postpone a foreclosure sale, obtain a forbearance from a lender, assist the homeowner in exercising the right of redemption, save the homeowner's residence from foreclosure, or negotiate the loan to prevent foreclosure. And so, I would ask kind of as we think about kind of these questions, and this is tangential a little bit to the bigger picture conversation we're having today, but also directly relates. Can you represent, this buyer or this seller, this borrower in this transaction? Can you help them stop or postpone a foreclosure sale? And kind of what are the rules? And so, again, I don't think that we've talked about this a lot. And so I think it's good for everyone to kind of see and understand this. Continuing in that same statute, these are the requirements in Missouri. Every contract with a foreclosure consultant must be in writing, must fully disclose the nature of the exact nature of the services to be provided, the total amount, and the terms of compensation. It also must include a notice of cancellation, allowing the homeowner to cancel the contract within 3 days. And so I would ask that question right now for anyone that is going out there and advertising to someone. And sorry for my dog and the squeak toy. I'm going to see if I can kick her away in a second. But if you're going out and advertising these services of stopping a foreclosure sale, are you thinking about this law? Are you putting it in writing? How does your compensation come into play? And obviously, if you're purchasing the property and that kind of thing, that might be your compensation, but does that need to be disclosed in the contract? And so, again, these are things to think about. Foreclosure consultant loans could be an error by itself, but something to think about. Other things just to think about here too. Other prohibited activities within that same statute is to collect, demand, charge, or receive any compensation prior to performing the services, receiving a fee that exceeds 10% of the loan amount, or taking any wage or lien on the property. And so I think, again, things to think about here. If you are engaging in these activities where you're dealing in the pre-foreclosure world and you're getting into a contract and then you're putting a lien on the property as an affidavit of equitable interest for, your interest in the contract, are you in violation of the statute? And I can't tell you here if you are or aren't. Everything's going to be case specific, but things for people to think about. And then last on this topic, and then we're going to move more into the conflict of interest side, but is what are the penalties? If you violate the specific statute, there can be civil penalties, including fines, possibly imprisonment, or homeowners may sue you, which again is that instance that I mentioned a minute ago that I know is going on. You can be sued by a homeowner if you didn't comply with these laws. And so I think part of why I wanted to talk about this in particular, and it's a little off topic because it's not directly related to this question of can you represent someone? You can represent someone in this sense as a foreclosure consultant, but you have, these different requirements that you have to comply with. And I think that that's part of the thing to think about is, as you provide these different services or as you are going to say that you're going to represent somebody, you have other laws that you need to think about, other rules, especially when you have a conflicting interest. So, all right. Now I'm going to take a deep breath. We're going to kind of transition to what is more the meat and potatoes of what I wanted to talk about today, which is this idea of can a wholesaler represent a buyer or seller? And by that, I mean, can you be their contact person? Can you relay information? What can you do those things? And I'm going to pose this out as a question for everyone to think about. And we're going to come back to this exact question at the end of the day, as we've talked about some of the other things, the other rules, laws, statutes as they apply. And the question is what's the ultimate goal of a wholesaler? What are you trying to do? And I know that some of you on here are going to give me your mission statement or your vision statement or what you formed at that retreat last month, where you're saying that you're trying to help homeowners and you want to put them in better positions and all of those things. Excuse me. And I'm not going to disagree that that is one of your goals. Many wholesalers that I work with act completely in trying to be a good person, help people, and that kind of thing. But unless you're doing it volunteer, unless you have another income, unless you aren't charging services, that's not really your ultimate goal, right? Or that's not really your only goal. That's not the only thing that you're looking at here. And Lisa, you nailed it where I'm going to get to this. Your ultimate goal, whether you have a secondary goal because you're a good person, you're a good Christian, whatever it might be, you're trying to help them, your ultimate goal is to make money. And I want to think about that idea of making money in two different statements, not just the money, but let's think about it in the two sides to a wholesale transaction, right? So side number one is your interactions with your seller. Your number one goal is to contract the purchase of real estate. Maybe not buy it because you might be assigning it or buying it if you're wholesaling it. But your number one goal here is to purchase real property for less than the market value to make a profit, right? You can't disagree with that. If you are purchasing it for more than the market value, you're not going to make money. If you're purchasing it for the market value, you're not going to make money. You need to purchase it for less than the market value so that you can sell the property, right? The other side of the transaction, again, I want you to think about these because we're going to talk about them as I talk about some other concepts, ideas, and laws as we go through today, is the buyer side. Your goal in this instance is to sell the property or the contract, depending on if you're wholesaling or assigning, for more than what you put it under contract with the seller at. Again, I don't think anyone here does this as a hobby or does this for fun. We aren't giving away money. We aren't charity organizations. Wholesalers are looking to sell that property to someone or that contract for more money. And so keep that in mind as we talk for the next, and I don't have my clock up here, so Kim, you might have to stop me at some point here. But as we talk for the next however many minutes we have left here, keep those two concepts in mind and keep them at your core. And I'm going to talk about those a little bit as we talk about other industries as well. And I want you to think about other industries and how these same concepts come into play in those industries. So, conflicts of interest. What I'm going to argue for you here today, and I think well supported by the laws, thank you, Kim, is this idea of real estate investors and specifically wholesalers or assigners having a conflict of interest in the transaction. And so to think about that, we need to think about what is a conflict of interest. And I'm going to talk about it generally, not specifically just with real estate to start here. And so, it's any situation where an individual's personal influences could improperly influence their professional duties. And so, as we talked about a minute ago, no matter how much you want to help that seller, no matter how much you are going to do for that seller, at the end of the day, you're trying to buy the property for them for less than market value so you can make money. And that's where your interest is. Even if you buy it for $1,000 less or $500 less, you're trying to do something. And that is not what's in the best interest of the seller. Because what's in the best interest of the seller is to make the most, also to take into account what other circumstances might be going on. And there might be reasons why they agree to less. But, obviously no one's wanting to give away money. And so you got to think about how your interest and their interest are not the same. You can be aligned in a lot of things. You can work together. You can be cooperative. But at the end of the day, that core interest is opposite of each other. And so, I felt that maybe to kind of understand this, because I know that when I talk about this, I frustrate a lot of wholesalers at times. that it's good to think about how conflicts of interest play in other businesses, right? And so, whenever you're in another business, we have conflict of interest rules all over the place. And they look at those financial interests. And so corporate governance is a great topic. And so, this is a nonprofit corporation I'm going to talk about, but I'm on the board of an association called Foster Adopt Connect, that helps work with foster children, adopted children, those that age out of the system, that kind of thing. I serve on that board, and every year I have to fill out forms talking about my financial interest. Is there anything that, like, am I providing legal services to that company? Do we do their closings? Am I getting any kind of financial benefit? If I am, that might potentially be something that would disqualify me from being on the board. Financial advisors, when they get their licensing, they have certain rules and restrictions on them as far as, can we sell certain products that, maybe you have an ownership interest, or maybe that advisor has an ownership interest in. Where are these financial interests? And so, again, this idea that I'm talking about here is that, um, you know, every, or not every, but maybe every business has these considerations. And I think that many of us as real estate investors recognize these conflicts of interest in other situations, but maybe don't recognize them when we're being a real estate investor, because we're driven by that vision statement, because we do want to help, and we do. But at the same token, we still underlying have that conflict. And I think that healthcare is maybe one of the best examples of that period. Those of you on this chat, again, I know at least half of you I know, you probably know I got a heart transplant back in 2020. And I do think it was a great decision. I'm the healthiest I've ever been, and I'm very happy. But one of the things to keep in mind is those doctors, they made over $1 million doing my heart transplant that year. And so when it comes down to the decision of, can we treat this with drugs? Can we treat this with transplants? Do they have interest that maybe push them in a different direction? And so I'm saying this to say that sometimes people take offense when I talk about this concept that real estate investors and wholesalers and assigners have conflicts of interest. And they're like, no, 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 I've actually had a person cry. I've had someone yell at me when I've tried to talk about this topic. And, but don't take it as an offense. It's not anything wrong. It doesn't mean that you're a greedy real estate investor. It doesn't mean that you're a bad person. Just like that doctor's not a bad person, but they may have something that's pushing them towards one course of treatment versus another because of their financial interest. At the end of the day, they care about getting me healed, right? They cared about getting me past my heart situation, but they do have that motivation. And so I'm hoping that this helps maybe soften this a little bit, that people can realize that conflict of interest isn't a dirty word. It isn't a bad thing. It isn't something that we need to feel ashamed about as real estate investors, or hide from, or pretend we don't have. We just need to acknowledge that and realize we do have a conflict of interest here because we are trying to make money. So the other instance that I thought was really good to talk about as an analogy is, the rules that apply to attorneys. And partly I'm defaulted to that because I am an attorney. But partly, I think it's a great example if we really think about it. What does an attorney do? Their entire job is to help someone, right? So someone comes to an attorney, you're going to need legal advice on maybe litigation, on maybe a situation, whatever it might be. And, the lawyer's job is to help the person. So it's exactly what we say in our mission statements, our vision statements, that we're doing for those sellers. But the rules that were drafted by attorneys, and attorneys are the greediest people in the world. I'll admit that all day, which is part of why I don't practice law. But even attorneys recognized, hey, we have this conflict of interest here, and we need to protect people from this. And so there are specific rules. This is taken from what's called the model rules, which is almost identical. I believe this particular rule is identical in Kansas and Missouri. Sometimes the model rules get tweaked a little bit on different rules, but these are the rules of ethics that basically apply to attorneys throughout the entire country. And you're going to see that specifically it says that they shall not enter into a business transaction with a client or knowingly acquire a ownership, possessory, security, or other financial, for those who don't know the word, pecuniary interest adverse to the client, unless certain things are made. And those things include the transaction terms in which the buyer or the lawyer acquires the interest are fair and reasonable and fully disclosed. And I can tell you as a lawyer that generally means market value. And so generally speaking, the way that most ethics boards are going to look at the situation is, if I, as a lawyer, wanted to buy a property, a real estate, maybe my client has come to me and said, we need to move from our house. It's the neighborhood that I want to move to. Everything is great. And I want to buy that property from them. I have to buy it at market value. I couldn't do the wholesaler thing. And so again, I'm hoping that seeing this illustrated through other professions helps to demonstrate why it applies to wholesalers and why it applies to investors. If a lawyer whose literal entire job is to protect that person and to represent their interest cannot do this kind of thing without a conflict of interest, I think it's fair to say the same thing applies to real estate investors. The other idea here, and this one maybe is a little more directly related to real estate investing, is real estate agents. And again, a lot of our agents are, or a lot of investors are agents, some are, some aren't. But think about these same kind of conflict of interest concepts that come in with real estate agency and the rules that prevent it. And so the first one that I would think about is this idea of dual agency. And so if you are a real estate agent who is acting as a wholesaler, you are essentially representing the buyer under the contract, right? Under the original contract, because you are representing yourself in this instance as the buyer, who then will assign it or sell it or whatever it might be, but in that transaction. And so then the question becomes, can you also represent the seller or the other side of the transaction? And what would the rules and regulations on that be? And so that's called dual agency. And so most time when people think about it, they think about it in the traditional sense, which is, can the agent represent both the real estate or both the buyer and the seller without being a principal, right? So just if John is selling to Sally, can I represent John and Sally? But what I want people to think about is that when you are Sally, the same rules are coming into play, right? And so you are representing Sally in this instance because you are Sally, right? And so can you represent both? I forgot, was it Tom or Dale or whatever I said for the first name and Sally? Can you represent them both at the same time? And so let's talk a little bit about the specific rules in Kansas and Missouri. And I did see the comment there. I think it was Travis who noted most brokers don't allow you to be a dual agent. That's true, and there's good reasons for it. Again, because of this conflict of interest that we're talking about. And then there's the question of the actual laws. You cannot do it in the state of Kansas, period. So if we're talking about a transaction that's taking place in the state of Kansas, you cannot be a dual agent. So you cannot represent Tom and Sally. You cannot represent the seller and the buyer. And if you're Sally, the same rules apply. Or if you're Tom, you are representing yourself. And so you would have a conflict of interest. You would not be able to represent both sides of the transaction. Missouri, the rule is a little bit different. There you can be a dual agent. We could discuss whether or not that's a good rule, but you can. But again, you have to get consent, written consent of the parties. They need to understand. And then there are kind of limited agency rules. And, this isn't to talk for real estate agents. Obviously, this is stuff you could have with your broker. But I think even looking at the Missouri law here, which does allow it, and at the very least, this is alerting us to the fact that this is something we need to be cognizant of. This is something we need to be telling our sellers and buyers about. And this is something, that is a potential issue. And that you're going to have that kind of conflict of interest. Another concept that really applies to real estate agents in particular, and I personally have a lot of kind of thoughts on this that I don't know everyone necessarily shares, but because there's an argument as to whether a wholesaler who is a real estate agent can even do both of those things at the same time. And I think that question really comes down to this question, which is the idea of what's a net listing. And so for anyone who hasn't heard of a net listing before, and this was back really kind of before the wholesale days and everything else, and what would happen is a real estate agent would go to that potential seller and they would say, hey, seller, what do you need to get when you're selling your house, right? And the seller says, I need 100,000. And the real estate agent knows, well, this house is worth 200,000. And so instead of saying I'll take a 3% commission or whatever negotiated rate that is, because of course it's not set, the real estate agent says, okay, well, let's do this. I'll guarantee you get 100,000 and my commission will be everything above that, right? That is a net listing. Now I'm going to ask you a question right now. Does that sound familiar? If you are a wholesaler, if you are a signer, does that sound familiar? And hopefully the answer is yes, because that's essentially what you're doing as a wholesaler or a signer as well, right? You're finding out that number that the seller needs to get. You're saying you're going to sell it for that, and they're going to get to keep anything above that amount. So what are the rules on net listings? Well, they're prohibited. This one is consistent in both states. And so the state of Missouri specifically prohibits it. Here's a reference to the regulation right there. Kansas, it isn't written into the rules and statutes, but the Real Estate Commission has a pretty strong stance that net listings are improper. I think any broker that you talk to is going to tell you that that they're considered prohibited, even if not explicitly written. And so, I want you to think about these kind of ideas and concepts that we're talking about here. And maybe you're not a real estate agent, right? But let's just pause for a minute before I move on to the next part of this talk and think about why I'm giving these ideas to you. Because even if you're not a real estate agent as a wholesaler, stop and think about why these rules are in place, right? And so why does an attorney or a real estate agent or a financial advisor or any of these people have rules that prevent them from both representing someone and receiving a financial interest in it? And the reason is because having that relationship where the person trusts you makes it easy to take advantage of someone. And what I want to say is that many times when you are taking advantage of someone in that situation, it is completely unknowingly. And so I know I'm saying a buzzword when I say take advantage of someone, and that's going to offend some people, but it doesn't have to be done knowingly, right? And you can have every good intention and every purpose in the world, but if you're trying to wear two hats and you're trying to both be the seller's advocate and be the buyer that's trying to get the best deal possible, go back to that original slide, to purchase the property for as low as possible, it's just impossible to do those two things at once. And so, no matter how good your intentions are, no matter how true you are, no matter how honest you are, it is impossible to wear both hats. It's impossible to be on both sides at the same time. And that's really why, there are these restrictions that make it hard or make it impossible, really, for a wholesaler to represent either party to the transaction. And I want people to think about, and I know I'm kind of nearing the end of my slide, so I talk about this a lot. And as again, we talk about why are regulations coming out? Why are people fighting wholesaling? Why are people pushing against it? And really, it's those 3 bullet points we talked about before. And this is that first one, which is, as wholesalers, no matter their intentions, no matter how good their hope is, try to represent the seller and try to wear two hats, which you can't do. The regulators, those in government positions, they look at this and they say, hey, this is something we need to do about. And so, that's where I really challenge people to think about how you can provide services to your seller, how you can be of service to them, how you can live and fulfill all of those mission statement, vision statements, but without trying to act like they're pseudo real estate agent, right? And so I said it again, I'll say it again, why you should listen to this. I know some people won't want to. I know this is being met with some hostility. I'm hoping if we have a few minutes for questions, some of you bring that out because I guarantee I'm going to get some. But again, I want to emphasize to you that I have no benefit from this. I gain nothing from telling us that we need to think about these things. The only thing that I'm gaining, and the reason that I wanted to share this message and that I talked to Kim about sharing this message, is trying to protect the real estate investor industry. Because again, when we blur these lines, when we aren't following the rules, that's what causes regulations to come down the pike. That's what causes us to get negative view. And I can't fix anything about that guy in Indiana that's making highball offers, right? And not following through on the contract. There's nothing I can do about that, but we can talk with the good investors. We can talk with each other in this community about ways we could recognize, acknowledge, and protect these conflict of interest that we all see. All right. I've got 2 more slides and then we'll move it to questions. And so these are the questions that I want to talk about that maybe get to the absolute core here, right? So what can you not do? And don't worry, I'm going to have a slide that talks about some of the things you can do as well in just a moment. And so, what can you not do? You cannot review or advise on documents for the buyer or seller. And so, again, a lot of these different examples are coming from my life in the title company where I've seen these things happen. And it is quite common that a wholesaler or a signer or real estate investor says to me, send me all the closing documents. I'd like to look them over and either give advice to the client, walk them through it, that kind of thing. Well, again, this is where you have that conflict of interest. And so you are coming from a great place. The real estate investors, the wholesalers, the assigners that say this to me, they are coming from a great place. And I want to emphasize that. I love where the motivation is because you are wanting to help your seller. But the problem is there's that ultimate conflict of interest. And a lot of times in these deals, there are terms, there are things that are related to your negotiation. Maybe there's a holdback because the seller's agree, gets to stay in the property for a little while. And there's terms of that holdback. Maybe it's just the terms of your contract in general, where, there are conflicting interest and what's best for them may not be what's best for you as a wholesaler. And so when you're trying to advise them, of the transaction, it's created that dual hat you can't wear. Other things you can't do, identify yourself as an agent on behalf of the buyer or seller. And so when you're contacting a title company, an attorney, a lender, whatever it might be, you don't want to put yourself out there and say, I'm an agent of this person. You can contact a lender and say, I've got an authorization, I'm the buyer. Maybe it's a short sale type situation. That's happened for years and years and years, right? Where a buyer might be in contact with the lender as the buyer, but you want to be identifying yourself as that person, not identifying yourself as someone that's representing the buyer or seller. Similarly, when you're working with title companies, lenders, that kind of things, you can't ask for information to be relayed or directed through you. Because again, you can't represent the buyer or seller. There's that inherent conflict of interest. You can't say that everything should go through me and that kind of thing. And then last and most importantly, and I think there's nuance in this that we should all think about, which is advising a buyer or seller that you represent them or that you're a real estate agent without making it clear that you're not their real estate agent. And so, one of the questions that I know is in kind of our pre-discussion on Facebook is whether or not you need to have an actual written, we do not represent you agreement. I don't know that you need to have it written. It's not a bad idea. It's never bad to put something in writing, but I think it's important that you have those conversations. And I can tell you as a title company that probably 50% of the time that we're dealing with an investor contract, the seller thinks that the wholesaler is their real estate agent. I get told that all the time. So, we ask them for some information and they go, well, I've already shared this with my agent. And I'm like, oh, you have an agent? Who's your agent? And then they go, oh, it's John Smith and it's the wholesaler. And so, I think that is, kind of two things from that. Number one, there are some people that I think are actually saying that to the buyer or seller. Hey, we are your real estate agent. We represent you. I think more people, though, are just not doing a good job of defining the roles, right? And so, I mentioned a minute ago, I do have a home investors franchise. I do buy and sell houses as well. I am also an attorney. I am also a real estate agent, right? So all of these hats where these conflict of interest apply. When I talk with a seller, I make it clear to them, and that's one of the things I state. I rarely talk about being an attorney because they don't even know I'm an attorney, so it doesn't matter. They don't have any reason to think I'm representing them unless that comes up. But I say to them, I am a real estate agent, but I am not your real estate agent. And it's almost that exact quote that I say every single time. I am a real estate agent, but I am not your real estate agent. And so, it's important that we make sure that people understand this. And I can tell you too, in my experience, and granted, I haven't bought as many houses as some people on here, but I've never had a seller tell me to get lost because I've made that disclosure or tell me that they aren't going to sell me their house because I've told them that I'm not their real estate agent. In fact, most of them appreciate it. They say, thank you for making sure, that we understand the roles, and then we move forward. All right. This is my last slide before I kind of open it up. I said I'd talk about the what can't you do. Let's talk about the other side. What can you do? Because I don't think that anyone should take away from this talk me saying you can't ever do anything to help a buyer or seller. That's absolutely not the case. It's just about kind of following those roles and making sure everyone understands their roles. And so, one good example of things that you can do is discuss situations with the seller, such as unexpectedly high payoffs, weird comma there, and negotiate the terms to take into account those situations. And so, what I mean by that is, what you can't do is ask the title company to send you the payoff and run everything through you, right? That would be representing them. But what you can do is when the seller tells you, hey, my payoff came up 10 grand more than I thought it was. I don't know if I can move forward with this deal. You can say, hey, let's talk about this. And maybe you're able to change the structure of your deal or do something, right? And so, you can still help them. You can still help that seller that's in that tough situation. Again, you're just doing it from that perspective. Is you're doing it from the perspective of, I'm your buyer. Let me see if I can make this work, right? Gathering documentation. And so, you absolutely can help with that. I've found, and some of these last couple points go to what I think, and maybe if we go into questions, I'll talk a little bit about that. What I've seen with investors that I think works really well from a title company perspective and in general, that's one of them. I mean, there's absolutely nothing wrong with, which note, I typed this with ChatGPT, so airship and the random comment there, I'm going to blame on ChatGPT, but the again, gathering documents, I think that, a lot of good investors do preliminary title searches, at least kind of checking what you can see in a 30-second search, right? And so if you've looked and you at least have gone to the county record, see they don't own it, and you know that it's actually their parents' house that inherited, start to get those affidavits, start to get those things. You can absolutely help with those things. Ask them to gather documents and provide those to the title company. Now, again, you don't want to tell them that you're their agent or that you're doing it. But what you can say is, as your buyer, I know we're going to need these things, this due diligence documents. We're going to work on getting that. Let's work together and get that over to the title company. And so I think that's definitely something else that you can do. And I think lastly, and I think this is where you really do kind of provide advice to a buyer or specifically seller. We're talking about a little bit more here today, but maybe not specific advice on their situation, is explain the closing process, how it works in everyone's roles. And again, the investors that I've seen where we have these great transactions, and I'm sure at least some of you have read the magic stories on Facebook at times of, we had a foreclosure and they closed that in 8 hours or something. And, a lot of that goes to do with the partners we're working with. It's the investors we're working with. And they, more than anything, they understand this third point. And because when you have those talks up front with your buyer and specifically your seller, to let them know this is the title company, this is their job, they're here to protect both of us, this is what they're going to do. Then when we call them to gather information, they're prepared. They know why we're calling. They're ready. And so, that's one of those things again that when there's these dual roles, it creates challenges for your title company. This is throughout the industry. I talk to other owners as well, because we try to talk to the seller and they go, well, I've already given all this to so and so. Or this person has it all because they don't understand you're the buyer, we're the title company. And so, I think that's really something else you can do to try to help your sellers. Some of my clients have infographics or flyers or handouts that they give them, things like that, that kind of says, these are the roles of the parties. This is what they can do. And again, that way you're helping them, but you're helping them without stepping into that role of being their real estate agent or stepping into that role of, saying that you represent them almost as an attorney, whatever it might be. But no, I'm helping you get to the resources. And lastly on that too, and I don't know if I put it in there, but you can also provide resources on, who people they could talk to. That is one thing that we do when we're buying houses is we say, here are different HUD counseling options that you can talk to if you're in foreclosure. Here's how you could find an attorney, give them those options to talk to their own independent professionals because, again, 99% of us are doing things right. We're being fair. We're being honest. If you're doing those things, you shouldn't be scared about them talking to their other advisors because their other advisors should tell them, yeah, they're doing the right thing, right? And so I think that's the other way is we can help is encourage them to talk to their own professionals and individuals. So I'll kind of stop for there and let's see. I've been reading the chats as we go, but they've been more comments than questions. Does anyone have any like specific questions or thoughts or want to yell at me or tell me I'm an idiot?
Well, I think everybody's agreeing with you throughout the whole conversation here is being transparent with what you're doing. Caleb says not, nobody should yell at you.
Caleb, people yell at me every day. But
I see this more. I haven't seen it of late because I haven't been out there advertising to build my buyers list, but people would sign up for my investor buyers list. And these are investors that supposedly know the roles of people in a transaction. And then they would email me or call me up and yell at me because I didn't put a property in front of them or a whole bunch of properties in front of them the next day. And I'm like, well, when I have a property to sell you, I will send it to you, but I'm not your real estate agent looking at a list of all these properties. If you want a real estate agent, you need to hire one. But they made it sound like the other wholesalers, the other real estate investors were acting as agents and showing them all their properties. And I just couldn't get it across to them. I'd explain it to them, but they didn't understand that I wasn't their investor and I wasn't finding all deals just to sell to that one person. They didn't get that. So
and I probably focus a little bit more on the seller side. But the buyer side, yeah, the exact same things apply, and you're completely right on that, is making sure that they understand. And I think one thing to remember, it's easy for us to know that most of the sellers are, and I use this term, specifically to real estate, unsophisticated. They may be incredibly smart. We deal with people that are professors or doctors, even just doctor the other day. But they may not know much about real estate, right? And so that's why these sellers are kind of less sophisticated parties. It's the same thing with wholesale buyers too, with investors. We've got investors that have done thousands and thousands of deals in Kansas City, obviously, and they know more than I do, right? We've got investors that this is their first deal. And so I think the same kind of thoughts about the conflict of interest and making sure that everyone understands the roles and things like that applies on the buyer side just as much as it does on the seller side.
and I would say this for those of you that are out there advertising, especially on the various Facebook groups. I have a friend because Ohio, I think, was the state that started this whole wholesale license law. And I have a friend that was a wholesaler in Ohio. And when their rules started, they started coming down. He says, well, I just won't post my properties out on Facebook anymore. I'll just send them to my email list. he did not know who was on his email list. He did not know that there were 3 or 4 people on his email list that all worked for the real estate commission, and they were out there signing up on all the wholesalers email lists just to see what they sent out so that they could fine them for violating their new licensing law or their new wholesale law. So I would also caution everybody, you don't know who's working for the real estate commission, who's a shopper for the real estate commission on your lists or on your on social media. So I would be very transparent about what you're doing on your emails. And all the emails I get pretty much are like, I'm this, they're very transparent. But some of the newbies just, I'm trying to sell this house, and I'm like, you don't own this house.
Well, and I think two parts on that point too is I think you're right completely that you don't know who's on your list, who might be there. The other thing is, especially in Kansas City, I think everyone on here will agree with me that Kansas City is maybe the most, if not at least one of the most competitive investor markets in the United States. And we have good investors and we have bad investors. And there are people that just try to spite other people. And so it may not be that it's an undercover person or a secret shopper. It may just literally be that Harry buys houses. I hope that's not a real person here. I just made that up. If anyone knows Harry, I'm not picking on him. But it just might be that Harry buys houses, doesn't like you, and doesn't like that you've done a ton of deals, and so he's going to turn you in, even though he's an actual end buyer. So,
And I know agents out there are turning people in. I've seen agents that they're talking to a seller, and the seller has a contract with a wholesaler, and they're taking that contract and sending it to the real estate commission. That's where a lot of the cease and desist letters come from.
yeah. And I
You
will
can
say, and
turn
I
on
didn't,
your mic and share, guys. We don't have a
yeah,
large crowd, so if you wanted to, you didn't want to type it out, you're more than welcome to talk to us.
Rick, this is Caleb.
yep.
I'm curious about the enforcement of the cease and desist stuff for non-licensed people. What really is the enforcement mechanism? Not that I want to enable people to be like free willy, do whatever you want because they can't come after me, but what are the real penalties there?
So ultimately, yes, they can send a cease and desist letter. They can go to the court to get an order. So they could go and get essentially a temporary restraining order, a TRO, which most people think of as protecting you from the abusive spouse, but it's also a TRO can be stopping someone from anything. So they
Sure.
could go get a court order. If that happened, violation of a TRO could lead to jail time or fines.
Okay.
That's really within a discretion of a judge. I mean, practically speaking, you're right. There's not a ton of enforcement in these areas at this point, but I do think over time there's going to be more and more. Especially as we don't make sure that we're doing everything the way we're supposed to do, and people keep pushing. The other part, which is where this does also fall within the Attorney General provisions as well. Regular consumer protection, and there hasn't been much action in that area either. But again, you never know when that's going to change. Especially when you're dealing with government, elected official agencies too. So those can change with any election. Kyle, I
Hey,
see your
on
hand.
that, I do know that Kansas had a company that was licensed in Missouri and doing auctions, and they then they were doing auctions in Kansas. They need to have a license to do that, and they weren't. They went through the it was in Johnson County. They went through the Johnson County District Attorney. They filed charges of against them and ended up with a settlement, and it was like a $5,000 fine. And then they had to either get licensed or stop doing auctions in the state of Kansas. So they generally they'll send the cease and desist if they continue to see that type of activity. Then they'll start to work with the district attorneys to file civil charges.
And why do we listen to Kyle is because Kyle's very active at Heartland and KCRER as a realtor. So he knows what they're doing legislatively as well. So
would it be past president at this moment? What is the?
It is. I'm no longer on the MLS. I passed the torch after 7 years of being on the MLS. I'm on the KCRR board and the Kansas Association of Realtors board. So we're lobbying our people for property rights, our legislators next 2 weeks on February 4th. We're going to Topeka on the Kansas side to lobby for home ownership rights and protecting the rights of the homeowner and the realtors, the ability to do business as well. So We have a list of 4 or 5 things. I can't tell you any of them right now, but we'll be there. Any Kansas realtors want to join us, it's a free conference. So
All
you can
right.
hear what we're about. But yeah,
So do we have any other questions? Because we are coming up on 1 o'clock, so that's right at an hour. And I knew we would go full hour here. Sometimes we do lunch and learns and they're only 20 minutes, but as long as we cover the topic, that's what we're trying to do. And it looks like we've got them all covered. Rick, I want to thank you for joining us. I might ask you to maybe write me out a quick article on your foreclosure consultant law, because I have a feeling that's going to be coming into play, or we might have to have a whole meeting on that, because I think we're going to be seeing a lot more short sales and learning more about short sales in the coming year. And so we kind of need to know what those laws are in Kansas and Missouri as we approach those short sale concepts.
Perfect. Sounds good to me. So.
And I want to thank everybody for joining us online and for paying attention. If you see a wholesaler out there that is totally clueless, please remind them that we have the video. Send them this video. We have another one out there also on wholesaling laws that we share publicly for free, because we're trying to protect our industry and educate our people that will only watch free YouTube videos. So we're trying to provide these for free so that our newbies that don't know they're breaking the rules can learn. So thank you, everybody. And if you're joining us tonight, we're talking on alternative housing. So ADUs, tiny houses, new construction, anything to build properties. We're having a meet and greet to meet everybody that has an interest in those topics on Zoom at 7 o'clock tonight. So I'll see you then.
Awesome. Thank you, everybody.
Stop recording. All right.